So now we're going to turn the program over to Gary Solomon. I'm sure some of you at least are familiar with Gary. He speaks for us on a very regular basis. Gary is the Director of Legal Support for the Legal Aid Society's Juvenile Rights Practice in New York City. Mr. Solomon participates in the New York State Appellate Division-sponsored training programs for assigned counsel and the Unified Court System-sponsored training programs for judges and court attorneys. Mr. Solomon prepares the weekly JRD newsletter, a compilation of annotated court decisions, which is made available to judges, lawyers, and other professionals throughout New York State and elsewhere. I believe Amy Hoodyetz of our office provides it to everybody on a weekly basis through email. And Mr. Solomon is also the principal author of volumes 1, 2, and 3 of the Practice Manual for Children's Attorneys. Mr. Solomon has received numerous awards, including the Howard Levine Award for Excellence in Juvenile Justice and Child Welfare, presented by the New York State Bar Association Committee on Children and the Law. Please help me welcome Gary Solomon.
So I thought I'd start just talking a little bit about conflicts of interest, and in particular sibling relationship issues, sibling, joint representation of sibling groups. And just sound a few themes first before getting into the weeds. The first thing is that we shouldn't, when you represent a sibling group, especially more than a couple of kids, 3, 4, 5, 6, 7, it's crazy. We should not be doing this. I just want to put that out there. Out in California, if you don't know, some years ago, it was quite a while ago now, there are a number of child advocacy organizations there. In most of the big jurisdictions, there are probably more organizations that do child advocacy as opposed to individual attorneys than there are in any other jurisdiction. And they're very active, and they all got together and they took a case up to the California Supreme Court, and they actually argued that I think they were doing dependency proceedings, which are our Article 10 proceedings. They were arguing that every child in California in one of these proceedings has a right to their own attorney. I don't know all the arguments they were making, probably under the state constitution, probably a due process argument of some kind. And when I read the decision, ultimately, I'll tell you what the California Supreme Court said. When I read the decision, ultimately, I thought to myself, this makes all the sense in the world. And that if there were enough, which I hope there are, competent attorneys to assign one to each child in a case. Now, we may decide that there's a cutoff, maybe 5, 6 years old, 4 years old, whatever age you use as your own informal cutoff for substituting judgment and those versus those cases in which you think you're bound by what the child wants. Obviously, a group of infants, who are 2, 3, 4, I think one attorney could be assigned to them. But once you're getting to the ages where normally you would be advocating for what the child wants, a very convincing argument could be made that every child should have their own lawyer. So what the California Supreme Court did is very instructive for us. And it's really what I tell people to try to do in their own practice in finessing, juggling, dealing with conflict issues. And this is sort of an overview. I'm not talking about specific cases or hypotheticals, but an overview, the approach that you should take to it. What the court did is first hold that there is no such right in California to a separate lawyer for each child. They also said specifically that the presumption is that when a lawyer in one of these cases picks up a sibling group, the presumption is that they can handle all of the kids. And the language in the decision suggests that they don't want lawyers getting skittish. They don't want lawyers kind of, coming up with hypotheticals or worrying about things that might play out at some point, that there's a certain amount of wiggle room where you can see that there may be some different views and maybe some interests that are not quite in line with each other as you're looking at each one of the children. But the suggestion from the California court, and I can simply tell you that I think it's the way the New York courts have dealt with this, is that they don't want you running off and asking for disqualification only because you see a problem lurking there. that they really want you to wait a while. Now, obviously, this creates some risks if you're in a situation like that, because if the conflict explodes finally later on in the case, it can create a mistrial. It can necessitate you getting off the entire case and another person getting assigned. Obviously, it can foster delays. It can have a very disruptive effect. But by the same token, the courts have decided that they'd rather take that chance. They'd rather sort of have that group of cases than have you at the very beginning of a case sort of jump on things that you see and ask for multiple attorneys to be assigned. Other things the California court mentioned, if you haven't thought of this already, which kind of makes it unwieldy to have a whole bunch of AFCs in a case, and one reason why I think the New York courts are rather indulgent in figuring out ways to say that you can manage representing multiple kids, even though they seem not to be saying quite the same thing, is the cost and the convenience. And the California Supreme Court actually got into that a little bit. I haven't looked at the case in a long time, but I remember this. In number one, talking about the cost to the state in a case with a whole bunch of siblings in assigning different lawyers. They didn't mention it in the way I might now, but can you imagine having 10 lawyers in the courtroom? First of all, you've got to find seating for them. If you're going to a hearing, you have to deal with the ego-driven desire of every lawyer to do their own cross-examination, whether or not everybody else has covered everything or not. How do you control that kind of thing? So they recognized all of this. They recognized what it would be like to try to find an adjourn date with 10 different lawyers there. So if you don't know, courts think about these things. Courts are not dumb. Courts sort of project and understand the system and how things work, and they think ahead, when you're coming up with an idea like separate lawyers for all the children. And they might even be tempted by the idea theoretically, but in the back of their mind, they're always thinking, like, how would we actually do this in real life? So the momentum in the system, in other words, goes towards you trying to figure out ways to stay on a case if you need to. For me, the risks and the difficulties really depend on what the issues in the case are that the kids are disagreeing about. Certain things are never going to be worked out, and other things you can. So let me just talk about that in general, and it's kind of a rule of thumb for you to be thinking about. So the classic hypothetical that I like to raise for people, which puts everything into stark, contrast, is an Article 10 case where you might have, say, a 14-year-old stepdaughter of the respondent stepfather or paramour, boyfriend, and you also have on the petition a couple of teenage boys who are the biological children of the accused stepfather, boyfriend, whatever. Blended family kind of scenario. And is there anybody here, raise your hand if you see a petition, if you saw a petition like that with those facts. 14-year-old, allegedly sexually abused, stepdaughter, or just daughter of the girlfriend, live-in girlfriend, and the two biological sons of the accused. Would you immediately start to think that I may have a problem in this case? Raise your hand if you think. Okay, so I sometimes say to people, you wouldn't be nuts if you actually went into the judge in a case like that and said, you know what, I've been doing this for 20 years. This has smoke all over it. I don't know if there's a fire or not. I haven't spoken to the kids yet, but there's smoke all over this. It's a scenario that very often plays out with the boys being on the opposite side from the girl. And so I think I'll take the assignment to the girl. At legal aid in New York City, whenever we get off a case, our rule of thumb is that we always take the child we think needs the services of the court and a lawyer more than the other kids, the child who's in the most danger. And we do have a lot of resources connected to our office to offer, so we feel comfortable doing that kind of thing. Social workers, all kinds of support. And judge assigns somebody else to represent the boys. I don't even want to get into this. That's not really what the courts want you to do, though. at least in New York City. They want you to at least sort of get into the thing a little bit. So how do you do that kind of thing, you know, and try to avoid conflicts that are going to explode later on? Well, one way is to start talking to the DSS attorney, talk to the caseworker if the DSS attorney allows you to, if you can work that out, and try to find out as much as you possibly can about what the kids are actually saying, because you may find out immediately because they've probably interviewed all the kids, and you may hear from the caseworker, oh, the boys say she's lying, they say she does this all the time, they say she's got lots of boyfriends, and you know, she's coming up with an excuse for something. Whatever it happens to be, you know, that's a case you may not even want to start out with the boys. You know, you may just want to take the girl and say, you have a good faith basis for believing that you don't even want to get into the case beyond just representing the girl. That's fine. You may not have that kind of information. You may have a slightly, you know, different permutation of what I just described as the makeup of the kids and their biological relationship. So it might not be as clear cut, and the information you get back might not be as much of a red flag. So you could stay on a case like that. You could, now, let's talk about the different issues that can come up. One issue that could come up is removal, you know, the so-called the 1028 hearing, you know, the demand for the return of the children. But one of the interesting things that happens in these cases is that the girl is removed, very common scenario, the girl is removed, she's put into foster care, and the boys stay home because there's not seen to be an immediate serious threat of harm to them, which is not an unreasonable position to take. So you may be facing a situation where the parents come in and no one's asking for the girl to be returned home. The boys are home, so nobody's going to be asking for a removal hearing. So whatever the kids are going to say, whatever you're going to be faced with, you don't have to do anything right away. You're not going to have a 1028 hearing. You know, kind of the issue is not going to be joined at that point. You could just, in theory, just kind of float for a little bit, you know, and find out a little bit more about the case. You're not faced with that immediate issue that you would have been faced with if the parent had come in on the very first day and said, we want her back. We want her back in the home too, in which case you might have a hearing where the girl's position is going to be different from the boy's position, which could be a serious problem at the hearing, especially if the boys could be called as witnesses, if they are saying affirmative things about the girl lying, as opposed to just, I don't know what's going on, but you know, my dad would never do anything like that, whatever position they're taking. So you could, in theory, just kind of float along, check out the case, start talking to people, and not think to yourself that you have a problem. What about fact-finding? Now, if you had to actually go to a fact-finding hearing in this case, and the girl is asking for a finding because she doesn't want to go back, she wants to stay wherever she is, whether it's with a relative or in stranger foster care. The boys, obviously, if they're home, they're probably not going to want a sexual abuse finding against their dad, right? So if you go into it with them, you know, they're not even going to care whether he did it or not. They're not going to want the finding against him. And that also could put them at risk because they're probably on the petition as derivatively abused or neglected kids. So you couldn't actually litigate a fact-finding hearing in that scenario. Then again, there are lawyers, and I'm just telling you what lawyers in my own office do. I'm not going to give you final answers to these things. I just want to sort of throw out possibilities. You know, you all have to work out how you want to do this kind of practice. Sometimes in these cases, though, for you to go to the fact-finding hearing, sometimes what people do is they say, well, I can go to the fact-finding hearing and I can argue for a finding of sexual abuse as to the girl, but I can argue for no derivative neglect or abuse as to the boys. I can do both of those things at the same time. And in theory, by the way, it may be entirely possible to make that latter argument on behalf of the boys, why whatever happened to her, they're not at any kind of risk. Now, the case law actually is very mixed on this. You know, there are some cases that say things like anybody who would commit acts of sexual abuse like this has such a defect in parenting ability that they would present a threat to any child in the home. They very rarely explain exactly what that threat is. You know, I think the supposition is that there's something deeply, deeply wrong with someone who commits those sex crimes, which is not an unreasonable proposition, and that we may not know what they're going to do to the boys in this particular case. We don't know how they're going to neglect them. Even if we don't think they're going to sexually abuse them, we don't know how they're going to neglect them, but we think the boys are an imminent risk. I have sympathies, by the way, with both sides of this argument, because I don't really know for sure that anybody can really articulate what it is that's going to happen to the boys. Yes, they're going to be around somebody who's capable of committing acts of sexual abuse, but it's still, you know, a bit of some speculation in assuming somehow they're going to be harmed by all of this. But the courts go both ways. So you could make this argument in court that the boys are not derivatively neglected. What's the problem with making that argument? You know, I don't want to do this as a Socratic dialogue because we have such limited time. But so I'll do all the counter arguments. So the flip side of that is, okay, should a lawyer go into a hearing like that for the boys, giving up entirely one argument that they might have made, i.e. that the sexual abuse never occurred? Because if you're going to go into that hearing and do that, you're going to have to make the argument that the sexual abuse occurred. And that already puts the boys in jeopardy. In fact, it puts them in deep jeopardy of having the derivative finding. So if a lawyer just represented the boys, they would never do that. They would probably ask that the charges be dismissed, the underlying charges. So for you to juggle it like that, I mean, this is a wonderful example of how some AFCs I know, and frankly, I think judges very often wouldn't be upset about this, especially if they understood the process, how sometimes people allow a far from ideal, in fact, kind of scary situation to go on, but they feel like they can finesse it, and the conflict doesn't really rear its head completely until later on in the case, so getting off would be disruptive. But this is one way in which someone can try to float above a dangerous conflict situation and still give all the kids good representation. Now, but again, the counter argument is, how can a lawyer go into that hearing knowing that they have one hand tied behind their back, which is they can't make the argument for dismissal? What's the counter argument to that? Well, if the proof of sexual abuse is overwhelming and indisputable, the guy made a confession. I mean, as you know, people do not like to make admissions in family court to sexual abuse. Most of the time, at least in my experience, they'll take it to a hearing, no matter how, you know, how overwhelming the evidence is. If the evidence is so overwhelming that no rational AFC who wants to be taken seriously as they're arguing for no derivative finding, that no rational AFC would make the argument that the proof of sexual abuse is insufficient, then you're not really giving anything up when you go in. So I get into these, again, Socratic dialogues with lawyers in my own office who come out in different ways and on different sides of this issue, which is why I'm throwing this out to you, and I'm not going to answer the question about when you get off and what kinds of signals you need to stay off a case. I'm just telling you that when circumstances allow somebody in a defensible way to stay in a very scary, dangerous conflict, quote unquote, situation, but they can work their way through the different positions and still do a really solid job for all the kids, a lot of times they try to do it. Are they kidding themselves sometimes? I hope not. Probably here and there. But, you know, I laid out for you just now really how that process works, you know, how one has to think about these conflicts in order to try to figure out ways to deal with them. There are other practical aspects to this also. How do you avoid getting into this situation? Structured interviewing is a good idea, trying to figure out a way to structure your interviews so you come on to conflicts before you get too deep into the case, because the operating principle and fear here is that once you're in the case, once you've interviewed all the kids and a conflict comes up, you're out, you're gone from representing all of the kids. The one I'll throw in a little side digression. The one exception to that, and you should keep this in mind, is if you get into a case and everybody seems to be in alignment, and then a teenage child completely changes their position, and all of a sudden they're not aligned with their sibling. If the sibling is an infant, and you basically had no contacts with the infant, any meaningful contacts with the infant, you have no confidential communications from them, you could at that point stay on the case for the teenager and just get off the case for the infant. Because the fear, once you stay on the case, is that you're going to have confidential communications from the former client that could be used to their disadvantage. And if there's a conflict, obviously that risk inheres. But if the other child that you're getting relieved from was an infant and they never said anything to you that could possibly be used, then the only thing you're doing is switching allegiances to the infant. And, I don't want to be too glib about it, but that's not a big deal, right? That a duty of loyalty or there isn't really any way that you're going to be double-crossing or violating confidentiality for the infant. So yeah, it's a little weird. You might have made some arguments earlier on that contradict what you're going to say now, but that again inheres in the circumstances if you have to get off later on. So don't get off the entire case if you have a conflict that arises later on, if you're able to say to the judge, I never had any meaningful communications with the client that I'm giving up. So, the classic scenario would be a teenager who wants out of the home, and you also, because you believe the allegations and they're serious enough, you want the infant out of the home, and then the teenager recants. So they're recanting, now they want to go back to the home. Now you've got a 14 or 15-year-old who wants you to try to get them home. But as a substituting judgment AFC, you don't want the infant to go back home because you personally believe, and from the evidence you think, it did happen. That's sort of the classic scenario I'm talking about, the recantation scenario. So as I said, in a scenario like that, what you should do is get rid of the, excuse the expression, get rid of the infant and stick with the teenager, because in that case you can do that. But structured interviewing is a way to deal with this. One of the things I always tell people is start out with the most problematic child, which in the scenario I gave you earlier on, of course, would be the allegedly sexually abused girl. So you're definitely going to start your interviewing process with her. Do never in that kind of scenario start with anybody other than the allegedly sexually abused child. Go through your interview with her, find out as much as you can. Also find out from her what she thinks the boys are going to tell you, or what they've said already, or just get her to talk about the boys or the siblings, the other kids in the household. And to some extent, you'll rely on what she tells you. If you hear from her enough to convince you that the boys are going to be adversarial to her, then you won't go any further. There's no reason to take that risk. You have now a good faith basis for going into the court and asking to be relieved from the other kids. You don't want to be revealing confidential communications. I hope your judges trust you enough. Sometimes in conflict scenarios, we run into the problem of judges not wanting to disrupt the proceeding. Now, obviously, at the very beginning of a proceeding, before much has happened, I think judges are not going to be that resistant. But later on in the proceeding, judges are kind of loath to declare mistrials. So sometimes they actually want you to say a little more than, Your Honor, I'm very sorry, but an irremediable conflict has developed and I've got to get off the case. The stakes are much higher for the judge then. I hope judges trust you when you say, Judge, please, to say much more or any more, I would have to disclose confidential communications. I really don't want to do that. So it does become a separate kind of issue when a judge gives you a hard time about something like that. So I won't go into that all that much more. The point is you reveal incrementally as little as you possibly can until you get the judge to the point where they realize that they got to let you off the case. But if you haven't been in that kind of scenario, they can be very, very uncomfortable. especially, for instance, in juvenile delinquency cases, if you're in the middle of trial and a conflict of some kind develops and you want to get off and they think it's a defense, a defense scheme, you're trying to get a mistrial, for your client's advantage. They don't usually think that way in child protective cases. I'm sure they don't think that way in custody cases, visitation cases, things like that. But in delinquency cases, very often you get pushback. You said, whoa, what's going on here? Is this a defense game that's going on? So what else can you do to structure the interviewing safely? Well, if you get through the interview with the first child, whoever that happens to be, and you don't have enough information to tell you that you shouldn't go any further, here's a trick to use if you haven't thought of this yet. And we had a case a number of years ago now where one of our attorneys on the first day a case was in court, went out into the waiting room, and one of the children was actually there, present in the courthouse, which is unusual, at least in New York, for the kids to be produced on the first day. We're usually going in blind, to advocate in the first hearing. We don't know anything about what the kids are saying. And just as another aside on the AFC role, we train our lawyers that for teenagers, they're not allowed to take positions at the original 1027 removal hearing if they haven't met the child, because they don't know what the child wants, and who are they to be saying anything at the removal hearing? A lot of the judges do not like that, but they've had to get used to it because with our role change, we're much more sensitive to this kind of thing. So the lawyer spoke to the child in the waiting room. It was a 16-year-old child. She didn't get very far before she was dragged by a court officer to a courtroom to do a case. Very typical, in busy New York City family court. It's also probably not atypical to almost get dragged. There's physical contact sometimes, at least when I was practicing. My elbow would get pulled. Nope, sorry, interview's over, counselor. The judge wants you in part 2, whatever it happens to be. Anyway, so the lawyer broke off the contact with the child and never saw the child again that day. Subsequently, she calls in the other children, and she finds out from her interviews with the other children that there's a terrible conflict between them and the 16-year-old with whom she had had the exchange in the waiting room. So she goes into the judge, and she said, "Judge, I have to get off the 16-year-old. There's a conflict." And the judge says, "No, you're going to have to get off everybody." Really stupid thing. I don't know what was said in the courtroom, but I don't even know how it got this far. The judge said, "No, you have to get off everybody," and took her off everybody after the judge found out about the dialogue in the waiting room with the 16-year-old. Well, we decided downtown that this will not stand. We cannot allow a judge to do this kind of thing. We all got all got psyched. So we ran to the appellate division. We got a stay, and we eventually won the case. The appellate division saying that the lawyer had not developed enough of a connection to create any kind of risk, that she had gotten usable confidential information from the 16-year-old that could have been used to the disadvantage of the other kids. That was the way the record read, and they said there was no problem. So I thought to myself at that point, I immediately opened up my file on my computer where our manual is, which is the manual that Linda was referring to, which I otherwise call my vanity press. It sounds very impressive when you hear that I'm the author of different volumes of a practice manual, and I'll take credit for that. That's fine, but it's a vanity press manual. I've done other things too, but this particular thing is a vanity press manual. It's in-house and it's developed over 20, 25 years. So I immediately went in there and I went to the section on interviewing kids and on conflicts, and I wrote in a new paragraph. And I said, here's an idea. When you're doing an interview with a child, even if it's not in the waiting room, start out with a couple of I know it's counter to all you hear about interviewing children and how you should develop a relationship with them and rapport and all of that. But the stakes are very high here, and there's a way to do this without destroying the rapport that you're going to develop with the child. Ask a question or two that are designed specifically to tease out a conflict. First thing. And we actually had a case in the Bronx a couple of years ago where I spoke to the supervisor, and he said that they had read that in the manual and they had decided to do it. I was so happy, A, that someone had actually read the manual, but B, that somebody had actually used something from it, and they used that argument in response to a disqualification motion that was made by the parent's attorney in a child protective proceeding and won, making that argument. That's exactly what they had done in the case. They had started out by saying something to the child, like in the sex abuse case I described to you before, that hypothetical, you would open an interview with the boys, or the first boy, and you would say, all right, I just have one, I'm sorry to just jump to this, but I have one very quick question. You know why you're here. You know what your sister, stepsister, whatever terminology you want to use, you know what she's saying. I just want you to say very quickly, yes or no, do you believe that that happened? No, I don't. Okay, thank you. Yeah, I mean, it's going to be awkward, but, thank you, I'm sorry. Explain it in any way you want, the fact that they're going to need a new lawyer, et cetera, et cetera. But that's a way to find out, to tease out the conflict, and then you don't go any further. And then when the judge finds out, when you ask for disqualification, if somebody wants to get you off the whole case, that's your counter argument, which is, here's what happened. You can't reveal the communication, but you can represent that you never got into the substance of any of the allegations. You represent as an officer of the court that nothing was said to you that could possibly be used to the disadvantage of the other kid, at least as you see it at this point, and stay on the case. But this actually happened in one of our offices, and they did what I suggested they do, and they were allowed to stay on after that. So that's another way to deal with conflicts of interest, is to finesse it like that. A couple of other things I wanted to mention about conflicts. Waivers, if you look at the Code of Professional Responsibility, or the professional conduct rules, you see I go back to when it was called the Code of Professional Responsibility, but the rules of professional conduct, if you go there, you'll see that there's provision for waivers. And in theory, it's true. I mean, we have 15, 16, 17-year-old clients, sometimes 18 even. And are they capable in theory of waiving conflicts? Some people might think so. We don't do it. We have never done it. I don't know if the circumstances will ever come up when we feel comfortable doing it. This doesn't feel like a situation in which kids should be waiving conflicts that their lawyer has. So my own personal feeling is that we shouldn't be getting client waivers of conflicts. In some ways, it's more complicated than waiving Miranda warnings, for a kid to understand what the risks are in keeping the same lawyer who has a conflict. We know from criminal cases that when two people have the same lawyer, regardless of whether there's any evidence of a conflict, the judge has to do an allocution of both of them to make sure they understand the risks in being represented by one lawyer. And if the judge doesn't do that, it's going to be reversible error later on. I think it's called a Gomberg inquiry for anyone here who does criminal work. So it's taken very seriously in other scenarios. It's also why I tell people that it's only in our context that people don't take conflicts as seriously as they do in other places, because normally a lawyer is not allowed to represent more than one person unless there's an on-the-record waiver like that. When I started out many years ago, parents very often had one lawyer, even in termination of parental rights cases. And that stopped many years ago and never happens now. I'm assuming you never see anything like that, unless maybe they both go out and hire a private lawyer, which is a different kind of issue. But in any event, I discourage people from even contemplating the idea of having kids waive conflicts. The other final scenario I wanted to mention is just about getting involved in a case where your client is a former client. Now, most of the time I talk to people about this, it's important to do it with legal aid offices and people who are institutional providers, because they're more likely to run into this kind of thing. And the issues are more complicated because the courts have said that with big public interest law firms that just because one person in the law firm previously represented somebody that the law firm is now going to be adversarial to doesn't necessarily require disqualification, because you can build a conflict wall between the two lawyers. Because this doesn't really apply to you guys, the only scenario you could possibly face, I suppose, is a former client of yours, let's say a former PINS client or a former Article 10 client, or it could be a former client of any kind, who's now coming in as the respondent in a child protective proceeding, and you've been assigned to represent the children, and you're now going up against the former client. What do we do in a situation like that? Well, I mean, the general rule in the rules of professional conduct, the general rule is that if you are in fact adversarial to the former client now, and if the previous proceeding was substantially related to the present proceeding, which creates the risk that you got information from them in the prior proceeding that could be used to their disadvantage in the new proceeding, then you're out. You're done. You're gone. I mean, there is no way to build a conflict wall. The question for you is there enough of a distinction between the issues involved in the previous proceeding and the present proceeding so that you can seriously say to the judge, I can keep this case because this past case involved X, Y, and Z, and nothing possibly could have come up during that proceeding that would bear any relevance to this proceeding. Is that possible? I suppose it is. You want to be very careful with that. I think the inclination probably on the part of a judge would be to get you off of that case or not let you on, if you think about that. But that's the individual lawyer scenario in which this can come up. But again, you know, I don't want to get into too long-winded a discussion about that, given the fact that, you know, you don't have the same kinds of issues that we face in those cases. I'm looking quickly for something that I thought I had put aside, but I think I remember what they said. There are just a couple of recent cases I wanted to mention, or at least one that I remember about conflicts that give us some sense of how courts deal with this sort of thing. I'm just going to mention one because, frankly, the other one was a little cryptic, the way the court wrote it up. But there was a recent case, a visitation case, where the two kids wanted two different levels of contact with their parents. And I was going to mention that this is really, for us in legal aid, the classic scenario where we have been willing to deal with differences in the children's opinion and where we really do think this is a legitimate thing to do. I mean, we had a lawyer taken off a case some years ago when she was advocating for no contact with one child for the parent and a lot of contact with the other child. And the judge took us off the case, and we immediately went to the appellate division, got a stay, and won the case on appeal, because the appellate division agreed that when you're talking about kids' desires to be with their parents and visit and their preferences, very often there are idiosyncratic reasons why a child wants one thing and another child wants another thing that doesn't have to do literally with parental fitness. And that's what this very recent case said. I think it was a second department or first, I know it was a second or first department case. But what it said was that although the kids wanted different levels of contact, neither child was having the lawyer or was saying that there was parental unfitness. They just had their own personal reasons for wanting different levels of contact. That's the kind of distinction that you can make as an advocate. You know, maybe you've already been involved in cases where you've been able to do that. But that's sort of the classic scenario where there really literally is no reason to get off. Is it possible that you could end up at an adversarial hearing in a case like that, where maybe in order to get one child what they want, you're going to have to, you know, skew a little negative on the parent and create more of a risk that the other child won't get what they want? That can be a potential problem. And if that's what you're going to have to do, then that's a conflict, if you're actually going to have to play that out in court. So what? Yeah, I'm sorry, go ahead. Well, I think we're supposed to wait till you get the mic. Although everybody can hear you in this room.
Gotta get it for the audio.
It's for the audio, yeah, okay. I don't want to be difficult here.
So your office was able to represent both children in that case?
In the
or
visiting
just
scenario?
one?
Oh, no, both. Both.
Where one wanted a lot of visitation, the other didn't?
Yeah.
You were able to represent both?
Yes,
Okay.
yes.
Okay.
And it happened in the middle of the case, so we got thrown off both. We couldn't have, if we were going to get thrown off at all, we had to get thrown off both. But we went to the appellate division, because that was something we do all the time. We do it in child protective cases, where kids are in foster care or with a relative, and one kid wants X amount of visiting, another kid wants Y. I mean, we were doing that for so many years. We said, oh my gosh, if this is going to get us off a case.
So is that a reported case?
Yes, it is.
Do you have the site on it?
It's in your materials.
Okay.
I can give you that
Yeah,
answer.
I didn't print it out. That's fine. Thank you.
It is in there.
Appreciate it.
Oh, if you look through the materials on conflicts, you'll be amazed by the stuff you'll see. Really how liberal the courts are, which fuels part of what I say about the courts wanting us to try to figure out ways to stay on cases. All right, so the second thing I want to talk about a little bit is interviews with represented persons. The rule that prohibits you from communicating, I'll read the language, communicating or causing another to communicate about the subject of the representation with a party the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the prior consent of the other lawyer or is authorized by law to do so. You're all familiar with this rule generally. One interesting little twist on this I should mention, because it confused me for a long time and I hadn't revisited it until recently, is that the up front in the rule, it refers to a represented party, but elsewhere in the same rule, it didn't. They changed it some years ago from party to person. So somewhere else in the rule, it actually refers to person, but it still left this reference to party. The way the rule operates in real life, though, is if you have a litigant in your case who's not a party but is represented, I don't think anybody's going to make the argument that you're allowed to talk to them if they're represented. I think the way this rule is functioning is that any person who's actually in the proceeding, whether it's a grandparent who's intervened in an Article 10 proceeding to try to get custody. They're not a party, but they are an intervener, and they may be represented by counsel. You can't be talking to them even though they're not a party. So functionally, you should think of this more as represented person rather than just party. And that's really what the courts have done with it. So I just wanted to tell you, before I get deeper into it, I wanted to tell you about a very recent case, which I think is just wonderful. And I premise this by saying that, if you think, maybe just run through the different bars, bans that we're operating under and the kinds of proceedings that we do. So obviously, you're not going to be able to, in custody visitation cases, that you're not going to be able to interview any of the litigants, any of the competing custody seekers, parents, relatives who are represented by counsel. You can't talk to them, obviously. Also, flip side is they can't talk to your client because the courts have said that the child, even though the child, technically speaking, certainly the child is a person in the proceeding. Some courts have said in certain contexts that the child is not a party. But for purposes of this rule, whether it's party or person, the child is deemed to be a party, so they cannot talk to your client without going through you. And I'll get back to that in a couple of minutes. In a child protective proceeding, you obviously can't talk to the respondent without going through their attorney. The DSS caseworker is kind of an interesting flip on that, but I'll get back to that in a couple of minutes. And as I said, I'll get back to the issues raised when somebody speaks to your own client. But along those lines, there was this wonderful case that's not, I don't know if it's in the materials or not. I can't remember whether this came out, if it's even cited in there. If you're interested in it, it's a case called Anonymous 2017-1 versus Anonymous 2017-2. It's a Supreme Court. Oh, it is there. Great. Thank you, sir. Bottom of page 17 in the handout. But I want to tell you a little bit more about the case than appears in the blurb. It's just a blurb there, right? Which I think has a good deal of information. The attorney Let me tell you first what happened. The court granted the plaintiff father's, it's a matrimonial proceeding, the court granted the plaintiff father's motion to disqualify the defendant mother's counsel for violating this rule, 4.2, by talking to the children without their attorney's consent. Now, here's what happened in the case. The mother and her attorney believed that there was a private investigator working with the father and the police to engineer the arrest of the mother. So this is the information the lawyer had. And apparently there was some immediacy to it because they thought that this could happen any time now, that somebody was going to show up at the mother's home and arrest her because the father and the father's investigator were engineering this arrest. Now, this particular lawyer, I don't have time to get into it completely, is very, very well known for being a real zealous, edgy, sometimes at or over the line kind of advocate. Very involved, deeply involved. I'm not saying this in any way to be critical, certainly not the deeply involved part of it. We have a lot of our lawyers who sometimes go too far in having personal contact with kids. I mean, years ago, people in our offices, got in trouble sometimes, at least from an office policy point of view, when they would actually house clients. They would actually let clients stay with them. This is a lawyer cut from that cloth who I think gets involved with clients. Anyway, the lawyer goes over to the mother's house and he puts the mother and the kids in a car to drive them away to escape the imminent arrest. Wonderful stuff, right? Now, per se, is there anything unethical about that? I mean, they didn't know for sure what was about to happen. I suppose the lawyer could say, I wasn't obstructing governmental administration. I wasn't doing anything like that. I think it would be very difficult to make out a case, but, it's a pretty edgy kind of thing to do. So the lawyer drives off with the mother and the children, but apparently in the car, it was assumed or it was known, I think there was a 6-day hearing that was conducted. So it was learned that the lawyer and the mother were talking about the father during the car ride, and the kids, of course, were a captive audience in the back seat. So what was happening was that the lawyer, not directly maybe, although it sounded like he might have even exchanged a few words with the kids, but even if he didn't, it sounded like communications were being had within earshot of the kids, and there was a de facto communication with the children of a negative spin on the father. So there was propaganda going back and forth in the car within earshot of the kids, and the judge said, whoop, you violated 4.2, off the case. So I thought it was just a wonderful fact pattern, but also to put some real teeth into the idea that lawyers on our cases should not be messing around with our clients. It's always been, I've always been aware that any very active lawyer in a custody visitation case who does things like make home visits and go to see their client in their home are going to run into the kids. And so I don't know what kind of practice lawyers in that scenario do. I don't know what they're like when they see the kids. You would assume that they don't say, go away, I can't talk to you. Or whether they warn their clients, I'm coming over to do an interview. I'm coming over because I want to see the home. I'm bringing somebody to take photographs. Have the kids off somewhere doing something else. I really don't want to be in the same room with them. It's not a good idea. Do lawyers do that? I mean, it would really be interesting to know what lawyers do in that scenario, whether they're that careful, whether other lawyers just kind of show up, walk around the house and hope that the children spontaneously volunteer something that's useful, and then say to the children, talk to your lawyer. If you have anything to say about the case, you should call your lawyer and tell them I'm not really supposed to talk to you. So I don't know how you handle that kind of thing. I know I tell lawyers that when you're in the waiting room in the courthouse and one of the adversarial litigants, the parent in a child protective case, comes up to you and says, I want to talk to you. I want to talk to you. You're the lawyer for the children. I want to talk to you. How do you handle that? And, we go through the whole script, how to discourage that sort of thing and how to, to turn them away because we can't take advantage of that. Or if they make a phone call, Now, if they leave a message on your phone with all this useful information, okay, fine. You know, I mean, you'll use it later on and you'll have a complete and utter defense to the allegation that you violated any ethics rules. You're not supposed to destroy information that a parent leaves on your message machine. So, you know, there are all kinds of different ways. Or if a parent yells behind you as you're walking away, you know, boy, you're rude, and then starts saying a whole bunch of things, you know, go back to your office or go into a corner and write it all down in your notes, what they said, because that wasn't your fault. You didn't do anything wrong. So it's an interesting kind of rule to navigate this whole idea of this. So, but in terms of our clients, let me just tell you a couple of things to keep in mind. The second department, primarily, but I think there are some other cases floating around. They're in your materials. They've been very, very careful and scrupulous in protecting our clients' rights and protection from this kind of overreach by parents' attorneys or any other attorneys in the case. And so they've put into place the potential in the case law, and you decide what you want to do. A, of precluding any evidence that's been generated because of the lawyer's improper contact with your client. Now, obviously, that would include statements made by your client. You'd certainly want to be making fruits arguments. You know, if they took statements made by your client and used those statements to uncover other evidence, then fine, you know, make your fruits of the poisonous tree argument that other things shouldn't come in. There's one case where the lawyer didn't do an interview of the children, but arranged for forensics by somebody hired by the parents. The children were seen, and so that was viewed as a violation of Rule 4.2. And all the forensic evidence was precluded by the court as punishment for the lawyer's violation. So, you know, be very aggressive if you see this kind of thing happen. You can also move for disqualification of the attorney, which, depending on what the arrangement is, could be a hit in their pocketbook. So, you know, if you want to go after them, if you want to, you know, fire a big shot across the bow, you know, you can do that. You know, that was my MO as an attorney. You know, I mean, call it passive aggressive, call it straight aggressive if you want. When somebody, you know, if somebody messed with my client, they were going to pay for it. You know, there was no forgiving. I was going to make it very clear to them, you better not do this again. So, you know, I was going to move for disqualification and preclusion. So keep a lookout there. There are other kind of counterintuitive, strange kinds of scenarios that come up with this. What about the DSS attorney on a case who wants to interview your client, and you're on the same side that they're on, and they're going to call your client as a witness at the fact-finding hearing, and they want to interview your client to prep them for the hearing? That comes under the rule. That's a contact with your client. Don't let them do that. I mean, whether you're going to go after them or not is a separate question. You know, you may just want to take them aside and say, don't you ever do that again. But you're not going to move for any kind of sanctions when they do that because you're on their side. But they should not be doing that. They should be going through you first. So, you know, I sometimes wonder, especially with a brand new DSS attorney, whether they think in those terms. And the other interesting part of this is that one of the exceptions in the rule, remember, because I mentioned it a few minutes ago, was when the contact is authorized by law. Now, U.S. attorneys in a whole series of cases that were litigated have long made the argument years ago that because of that exception for authorized by law, they were allowed, when they were conducting investigations into criminal activity, they were allowed to interview suspects or objects of the investigation who were not yet charged, but who had lawyers, usually white-collar criminals who had very high-priced lawyers. And so the U.S. Attorney's Office used to argue that we're authorized by law to do this because we're investigating criminal activity, and we're the U.S. Attorney's Office. Could the DSS attorney say the same thing? Could they say they're authorized by law to interview your client because they're prepping their case? I don't think they would. Could they? I don't know. I haven't seen the argument made. I'd be very surprised if they ever wanted to make. I mean, why would they want to get us annoyed when all they had to do is call us and give us a chance to sit in on the interview and, you know, and be there or have some input into it? Why would they want to take that on? The U.S. Attorney's Office, you can understand why they would want to take that on. because they want to get a free crack at a white-collar suspect without having to go through their attorney. So anyway, there's this other aspect of the rule, by the way, if you're not familiar with it, that essentially allows a lawyer to, I'll read the language, because people don't talk about this very often, cause a client to communicate with a represented person unless the represented person is not legally competent, which is language we want to remember, and may counsel the client with respect to those communications, provided the lawyer gives reasonable advance notice to the represented person's counsel that such communications will be taking place. So in practice, what does this actually mean? It means that a parent's attorney in a custody case could cause their client and advise them about having communications with the child who's represented by you and give them advice about what to say and follow-up questions and what kinds of contacts to have with the child, as long as they give you advance notice. So, from their point of view, if they think you're if they think you're not going to be on top of things and won't interfere, and they think you're going to be passive, all they really have to do is just give you advance notice and cross their fingers and hope you don't do anything about it. But from their point of view, now I've never heard of anybody doing this. I've seen no case law under this involving this sort of thing. But it's good to know that it's there, that that's actually a thing a lawyer can do, which is to cause a client to have these communications. And the first thing I wondered about when I saw that is, are matrimonial and visitation, custody, attorneys for parents, are they looking at this and thinking, can I do this, even if I can't talk to the children? So I did want to make everybody aware of that. Now, when it comes to caseworkers, which is the last thing I want to mention, in New York, we have a protocol that we worked out with the Administration for Children's Services, the DSS in New York City. We have a protocol we worked out with them regarding contacts that we're allowed to have with caseworkers. Now, a lot of this stuff spins off of this Court of Appeals case from many years ago called Nisig versus Team 1 that had to do with the ability of lawyers representing adversarial parties to interview employees of the other party or an adversarial party. And when the employees are deemed to be part of the broader umbrella term party, because remember, or person represented. So remember, the rule only bars an attorney from interviewing a represented party or person. It doesn't bar an attorney from interviewing someone who's not, quote unquote, represented. And an organization can't shield every single person that works for them from an interview by the attorney from the other side, assuming the person is willing to talk, which is a separate issue. But they can't shield them by arguing that every single person in this enormous organization is represented by the attorney who's representing the management group in litigation. So that case raised a lot of issues for us in family court practice around the question of interviewing DSS caseworkers. I think most of us bought into the idea, at least we thought it was arguable, that the caseworker, especially since they're generally the petitioner in the case, they're making allegations, sworn allegations, even if it's on information and belief, but sometimes on personal knowledge, that they're enough of a player in the case, and maybe they're part of the decision-making management group that's referred to that can commit the organization. That was the language used in NYSEG. Now, a lot of that language doesn't really travel very well when you bring it over to our child welfare context. But to the extent that we could do that, we thought to ourselves, all right, they have an argument that the caseworker is part of that, and maybe we shouldn't be interviewing them without going through the DSS attorney. But we solved the problem in New York by coming up with a protocol for what kinds of things we could talk to them about and what kinds of things we couldn't talk to them about. Because remember that the rule, again, the legally operative phrases in the rule only bars communications about the subject matter of the litigation. And the question is, what is the subject matter of the litigation? Does that include the foster parent's phone number? Does that include the nature of services that are being provided? Some people would say yes. Some people would say that if you're questioning a caseworker about the services that they're providing, you may be setting them up for a contempt charge if there are court orders in effect. So, there are a lot of different ways in which people can make different arguments. But in New York, we have a protocol. I don't know how you operate in your own jurisdictions. I don't know what DSS says to you about this. I don't know if they require you to go through the DSS attorney, how you deal with this rule. So I don't know how to answer it for you, except, to tell you that what we do in New York City, and one of the distinctions that's clearly made there is what is the quote unquote subject matter of the litigation. So we're not allowed to talk to the caseworkers about the underlying fundamental charges, about the validity of the charges. We're not allowed to negotiate outcomes with them, dispositions, particular things. So, and those things are very clearly the subject matter of the representation. But other more ancillary facts, you kind of have to make a judgment call about whether it seems to be the subject matter of the representation. The final thing I want to mention, and I don't know how far you really want to take this, before we developed the protocol and when we were still thinking adversarially, I found in my own research that there are First Amendment cases and opinions having to do with the right of an individual who's interacting and interfacing with the government to have their attorney advocate on their behalf with governmental officials. And these cases are based on the First Amendment. And I was all prepared, if we had actually had to litigate this with DSS in New York City, I was prepared to suggest to people that we raise our First Amendment arguments, because our clients, when they're in foster care, are not only interfacing with the government, they're at the mercy of the government for their food and clothing and shelter. And clearly, under these principles, we have a First Amendment right on behalf of the children to advocate with the government officials who have control over them. So I'm fully prepared to say that that's a legitimate argument for anybody to make. If somebody accuses them of having improper contacts with a caseworker or an agency employee, whether you want to take that on or not, I mean, I didn't really want to have to deal with it that way, and I was glad we developed the protocol so that we know what we can talk to them about and what we can't, or what we have to go through the attorney to find out. So anyway, those are my thoughts on that particular rule. By the way, the one last thing is talking to unrepresented people. The only real sticking point in that, the only danger that you run into, my time is 10:15, I think. Okay, I think I have a sense. The only real danger zone in that particular scenario is talking to an unrepresented person involved in your proceeding, a litigant in your proceeding, who is adversarial to your client. And when you are talking to an unrepresented person who's adversarial or potentially adversarial to your client, you're not allowed to give them any kind of legal advice. So you're not allowed to say anything to them that somebody could characterize later on as legal advice. So you have to be very careful about that, other than the advice to get an attorney. So be careful in those scenarios, because we used to have relatives come to us and want to talk to us when they were seeking custody of the child within the context of a proceeding. And maybe we already knew that we were going to be opposing their request, that there was somebody else we liked more. But we did want to get information from them. We did want to find out things from them. And there was nothing to stop us from interviewing them, but we had to be very careful not to give them anything that could be called legal advice, like what should I do about this? How should I handle this? Things like that, you want to be very careful about that. So the only other thing I really have time to talk about for a few minutes is the advocate witness rule, which prevents lawyers from being witnesses in proceedings. And I'll freewheel a little bit, because in 10 minutes, I don't know how much I can get into the details of all of this. Suffice to say that you know what the basic rule is, that a lawyer shall not act as an advocate before a tribunal in a proceeding in which you're representing somebody, or not act as an advocate in a proceeding in which you're likely to become a witness, and where it's necessary for you to become a witness and a significant issue of fact is presented. There are a lot of out clauses, and I kind of want to focus on those for a minute, on how you get out from under this kind of issue. Now, if you do interviews personally, and you interview people at a case, and you interview people who are potentially adversarial to your client, I mean, in juvenile delinquency cases, certainly if we ever get lucky enough to get a cop to talk to us, we're faced with this kind of risk. In child protective cases, custody cases, you never know really when you're interviewing somebody who's ultimately going to be adversarial. Well, if they go into trial and they give testimony that contradicts what they said to you, and there's a material discrepancy, you are now in advocate witness rule land. It's really the classic scenario is when the lawyer has a very important prior inconsistent statement that they got through an interview with somebody, and they've now become, unless there's some other way to prove it, they've now become a necessary witness in the case. So you're in trouble when that happens. So first, how do we avoid this kind of thing? Well, we try to avoid it in the most obvious way possible, which for us at Legal Aid is very easy to do, which is to have someone else in the room who can testify. We have social workers do interviews. We have them do interviews of our own clients with us so they can testify about what the client said at a hearing, so we don't have to do it. We have investigators who come to the scene with us. So if we see things that someone might have to testify about, we have an investigator who can do it. Taking photographs, by the way, is a great idea because photographs are very unlikely to lead to an advocate witness rule problem because you can probably find somebody else who can say it's a fair and accurate representation, so you'll never have to do it. And the fact that you were the photographer, or especially the fact that you were there, won't matter. So you're in a pretty good position in that case. And it's a lot more difficult for other people to make an issue out of a photograph because one of the out clauses in the rule is when the issue is not contested. So if you're going to give evidence about something that no one's really contesting, that's a way, and essentially they're going to stipulate to it, that's a way to get out from under the problem. It's why I say to people a lot of times that the way I recommend that our lawyers deal with an advocate witness problem, if a parent's attorney or another attorney is moving to disqualify them, is to ask for a conference. See, I don't know where to go with this, and this is the other side of the advocate witness rule that I wanted to talk about, is to go up to the judge, is ask for a conference in chambers or at the bench, wherever you want to go, bring everybody up, and turn to the attorney with whom I assume in many cases you practice very often, know personally, and have to deal with regularly, and turn to the attorney in front of the judge and say, all right, let me understand this correctly. You're not willing to stipulate to what I'm saying, and if I testify about it, you're going to cross-examine me to try to convince the judge that I'm lying? I mean, the lawyer might say, no, I would just do a credibility cross-examination, which is a bogus answer. I mean, it's really a ridiculous finesse of the issue. Essentially, they're going to be trying to convince the judge that you're lying. And I always suggest to people, pull the curtain aside and put family court practice out in the open because, we're not in another kind of court where people don't know each other and where a jury trial is involved and where the issues are different. We're in family court where, for the most part, I mean, this is certainly true in New York City, and I'm assuming in your jurisdictions too, it's the same players all the time. You all know each other. And one of the fundamental assumptions that has to underlie everything that goes on in your proceedings is that you're all believable, right? Because one of the anomalies around this rule, which I've remarked on at every training I've ever done, one of the great anomalies is that we have colloquy in court on a daily basis, not at the middle of trial, but off ancillary issues, things that are being dealt with outside the context of a formal fact-finding hearing, temporary orders, visits, different things, where we're all making allegations. Occasionally, we're even making allegations about things that we know personally, like what our clients have said to us or what witnesses have said to us, hearsay, admittedly. But we're essentially becoming witnesses. The only difference is that everybody else is doing the same thing. The other lawyers are saying what they heard and what they found out. You're saying what you found out. It's like a Wild West, unsworn witness fest where all the lawyers are repeating things. Anyone ever heard anyone complain about that? Anyone ever hear anyone interrupt and saying, oh my God, we're all violating the advocate witness rule. We can't do this. So it's one of the crazy things about family court practice until it's actually raised, which tends to happen in the middle of a fact-finding hearing, which is a formal hearing, and that's where it feels like there's something that's different, and to some extent there is. And one of the cases in your materials, I think it was the second department, found error where the judge started quizzing the AFC in the middle of an argument about the sufficiency of the pleadings and got information from the AFC that helped the judge decide the motion to dismiss. And the appellate division said, no, 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 no. You can't make a witness out of the AFC like that. But no one says anything in all the other contexts. You read other cases in the appellate division and they start alluding to things the law guardian, the AFC said at a hearing. Well, the AFC represented X, Y, and Z at the hearing. So when they want to say it's okay, they say it's okay. When they don't want to say it's okay, they don't say it's okay. Who knows what's going on? I mean, I will leave you with that thought. I don't know what's going on here. But I do know that in response to a motion to disqualify you, the first thing you should be doing is, you're not going to stipulate? You're going to cross-examine me? And that's the way to handle a motion to disqualify you in one of these cases. You can get into a dialogue the way I just did with you and say, Judge, I mean, really? Now, occasionally there are attorneys that judges in New York City that judges know lie, right? I mean, it's happened. And, their reputations go into the dust. 1 minute. Their reputations go directly into the dust. And, their supervisors are called in by judges and they tell them. They can't function effectively from that point on. So, we're in even if, I don't believe in misrepresentations and, I'm a pretty honest lawyer. But even if one is tempted to play with words and be cutesy with the way you represent something, it's a real danger in our own practice. And I've had to go in answering to judges about attorneys, and there was one in particular who was fully guilty of it, and I had conversations in private, and I said, you can't do things, you can't reveal one fact and leave out another that the judge is going to find out anyway. It's just, A, it's not ethical, and 2, it's stupid, because it's not even worth it. So anyway, so you have to watch out for these things, but that's what I would do in the advocate witness context. The only other thing I'll mention is that for those of us at Legal Aid, and by the way, for prosecutors and DSS attorneys and government lawyers in general, if you catch them in an advocate witness situation, all they have to do is pass it along to another lawyer. Because it's a personal issue. It's not an agency issue. It's a one-to-one personal problem with that individual lawyer. So they can get out from under it. We do it all the time. And that's what I tell our attorneys. I said, if worse comes to worse, fine, we'll put a new lawyer on the case. You can still work on the case in the background. You can still do everything you were doing before. The only thing you can't do is appear in court. So for us, it's really, the worst case scenario is not a very bad case scenario at all. For you, it's a lot different. And I think in the final word, I think in this context too, the judges are not going to want mistrials in the middle of a hearing where unexpectedly it seems that you need to testify about something that someone said to you in an interview. I don't think judges really want to do that. So I think you're going to have the judge on your side if you have that conference and you say, could we get a stipulation on this? So I think the judge is going to be on your side too. Was there I don't even know if there's time anymore. Okay? And did someone have a question, or you were just fidgeting? Okay, if I have a couple of minutes, is there anything else I care about saying? I can't get started with anything else. I'll just stop if there are no other questions anyway. Okay.